Agradaa. Richard, good evening. Thank you very much for your time, Council. I'm sure this is not what you were expecting.
Very well. We were not expecting this result at all. But in summary, the judgment delivered by the court today is nothing but travesty of justice. And we say so not because the decision did not go our way. We say so because we are deeply concerned about the reasonings of the court. You see, when prosecution, in fact, the accused person was charged with 1 count of charlatanic advertisement and 4 counts of defrauding by false pretenses. Initially, the claim of prosecution was that Agradaa had engaged in money doubling venture. So the trial commenced, they took evidence, and prosecution saw they could not sustain those charges. So they amended it and subsequently amended it further. So there were 3 different amendments, which are all allowed by the law anyway. But when prosecution closed their case, the judge ordered that we open our defense in respect of all the 5 counts. And we argued that in respect of count 4 and count 5, there seems to be no evidence whatsoever on record because the people who made that allegation did not come to court to testify at all. So it is travesty of justice for you to demand or request an accused person to open a defense in respect of a charge where evidence has not been led. She did not agree with us and asked us to open our defense anyway. But in today's judgment, she acquitted her on count 4 and count 5 and held that there is no evidence on record. So it means clearly, at the time that you ordered us to open our defense in respect of those charges, she had no basis whatsoever in law in giving that order. Now, we are also concerned about how the court analyzed the evidence, because this is a simple matter. We had 2 people come to court alleging that the accused person had conducted an online service in which they participated. And in that program, they were made to form queues. And the accused person parted away with their money in the sum of 540 Ghana cedis. Thankfully, we had video footage of the entire service. This footage was produced in court by prosecution itself. On the part of defense, we equally produced the same footage. So where the accused person constantly mentioned that these complainants, I don't know them. They did not come to my service. They had been planted outside my church. I don't know them. They did not participate. Then one would think that the basic thing to do is for prosecution to point us in the video. Let's say at 10th minute or at 15th minute, the first complainant or the second complainant is seen there in a black suit or in on that row. That did not happen. In the course of course examination, we asked them, you said you participated in the service. Can you tell us what the message was about? They couldn't tell us. The kind of songs, they couldn't tell us. Prayer points, they couldn't tell us. Who even did the MC on the day, they couldn't tell us. So nothing about them showed that they were indeed at the service. Yet you had a judge going by their accounts and totally ignoring whatever we put across. And we believe that once a complainant made a complaint and we have evidence, positive evidence on record, and they could have proved or showed us, and they failed on that, we believe that was fatal to their case. But that notwithstanding, the judge still went ahead and entered judgment against us. So that's the source of our disappointment.
So you feel your client was not treated fairly by the court?
At all. We believe that Agradaa has been jailed not because of what she did, but because of who she is. We believe that Agradaa has been loud on social media. She has stepped on several toes. The kind of language she uses is not that palatable. Some people don't like him. All of those things came to play because it is so basic. The man said, I was in the service. We have video footage before the court. So show us. But nothing of that happened, and yet still judgment has been entered again.
You feel there's a way to silence her?
We believe so.
So what's...
We believe so.
So after this particular, what is the council going to? I mean, the lawyer.
So the good thing is that this judgment is delivered by the circuit court. So there are appellate courts. We would file the necessary processes early Monday morning because tomorrow is a holiday. We're going to do that early Monday morning. You see, the point is that if the justice of the case requires that my client be incarcerated, so be it. But if the justice of the case requires her to be set free, we will go every length. Because how is this possible? That we have video recordings of the entire service before a court. The complainant, who the accused person claimed did not participate in the service, were not made to identify themselves in the video. And yet the lady promised that she was going to share money. We had the lady sharing the money. We saw the lady sharing the money in the video. And the judge's interpretation of that was that the people who received money in the video are all collaborators. And that is very unfortunate because the police themselves know their work. If the police were of the view that the people who received the money were collaborators, they would have charged them with conspiracy. But there was no such charge. So how would the judge move out of his way and analyze the evidence that people who were seen in the video were collaborators? It's something that we clearly can't come to head with it. We can't.
Can I conclude that you want to appeal this decision?
Oh, sure. That is very certain. That is certain. You see, the justice of the case requires her to be incarcerated. As lawyers, we are officers of the court, and we go to court, assist the court to administer substantive justice. But if the justice of the case requires her to be set free, why should he be incarcerated? This is so basic. The prosecutors laid charges for 4. 2 of them couldn't come, and the 2 people who came were not seen in the video. So how on earth would weight be placed on what they said? Weight is placed on everything that the CID said. But the CID said when he went to the church premises after the event, the place was locked and he could not get any access to the place. So how come we place weight on what the CID said and not the video footage that was put before the court? The video footage was put before the court. So how is that possible? How is that possible?
Counsel, where is your client now?
As of now, she is at the police headquarters.
Getting ready to be sent to whichever prison.
Sure.
Okay, thank you. Thank you very much for your time. Richard Asari Bafo, who is lawyer for Patricia Esiedua Esiama, also known as Nana Agradaa.